Good morning, everyone. Thank you very much for joining us this morning. I'd like to give you a very warm welcome to this conference hosted jointly by the Irish Centre for European Law and the Environmental Protection Agency. My name's Margaret Gray. I'm delighted to have been asked to chair this conference this morning, both as a member of the board of the ICEL and a senior counsel with a keen interest in the enforcement and development of environmental law in Ireland and in the EU. And I'm sure you'll agree with me that this year, having had previous similar conferences in Cork and in Dublin, we're now pushing the boundaries, going online, and I really believe that we have a wonderful virtual conference for you, which will provide the opportunity for you as attendees to contribute and interact in a new way in this new world that we are now operating in. So I would like to, from the beginning, extend a very great thanks both to Dr. Tom Ryan from the EPA and Dr. Áine Ryall from UCC, and also a board member of the ICEL, for really using a very great endeavour to get this conference online. So thank you very much to both of them. Before we start, the usual housekeeping points. I'd just like to run through really three issues about how we're going to operate today. The first is housekeeping generally. There is a poll that you will see. Please do enter your details. I believe that we have a phenomenal 300 people who have logged in so far, which is fantastic. So please don't forget to do that. Also, as regards the Q&A, we're very keen for you to submit questions and answers. I believe some people are so keen that questions have been coming in even before we went online this morning. So that's an encouraging sign. And also, if you are on Twitter, please do tweet the conference using the hashtag on the slide. So that's in relation to the housekeeping issues. As regards the agenda and the programme for this morning, you'll see that we have really a stellar lineup of speakers in the two panels that you're going to hear from this morning. We propose to run through the first session and then have a short coffee break from around 11 or perhaps a little bit after, depending on how our timing is going. But we will be resuming promptly at 11:30 to take up session 2. And then the third housekeeping point really is in relation to how the programme is going to run on the technical side. We have, in order to try and keep a smoother running conference for you as possible, recorded the papers that are being delivered by our speakers this morning in advance. But we do have a live question and answer session with the panel both this morning and then after the coffee break. I do need to flag that with apologies, Professor Richard McCrory cannot make the live Q&A, although you will be hearing his most interesting paper this morning. But we're very fortunate indeed, because Dr. Áine Ryall, who you're all very familiar with and has a vast knowledge and experience in this area, has very kindly volunteered, or perhaps been strong-armed into joining the panel this morning in Richard's place. So thank you very much, Áine, for stepping in to do that. And we'll also be hearing from Áine with her usual roundup, which always succinctly summarises the hot topics of the day. So one final thing, it is an intention that there will be a publication of the recordings of the talks, that is the pre-recorded talks, and we will be in touch by email to let you know the details of that in the future. So if I can just say that we're absolutely delighted that the Chief Justice, who has been such a supporter of this and previous conferences, is able to join us this morning to give a live address to the conference. Perhaps a state of the nation on environmental law, which was already very active last year when he spoke. And in fact, the last 12 months have proven that there has just been an continuing interesting run of cases both here and cases in Europe, and dialogue between our national courts in Europe. So we're delighted that we'll hear from the Chief Justice this morning. But the first speaker is Laura Burke. Laura is the Director General of the EPA. Once again, and with my ICEL hat on, we really are very, very grateful to the support that the EPA gives continually with this conference, and for Laura to make time to appear this morning to speak to us and address us on the EPA and what its current objectives are. So without further ado, over to you, Laura. Thank you very much.
Thank you very much, Margaret. And I am absolutely delighted to be here this morning, and welcome from a wet and wintry Wexford. Chief Justice Clarke, distinguished chair and speakers, ladies and gentlemen, on behalf of the EPA and our co-hosts, the Irish Centre for Environmental Law, we are really delighted to be able to welcome you to the conference today. And I think the topic, Environmental Law Enforcement Emerging Challenges 2020, is so topical and so important to be considering. And it's great as well that the conference itself has re-established itself as an important event on the environmental law calendar. I suppose, as Margaret has highlighted, we're all coming to terms with working in this virtual environment, which of course has its challenges, but also its opportunities. And I think on the one hand, we really miss the opportunity of getting together over coffee and talking on the margins of events like this. But on the other hand, this has given us an opportunity to open up the conference to a much wider audience and a much more diverse range of participants than we would have been able to otherwise. And as Margaret has mentioned, having 300 people already online for this conference is absolutely brilliant. Now, unfortunately, one of the casualties of this year is that our session involving PhD candidates presenting their cutting edge research we weren't able to have, but we hope that we'll be able to include this innovative session again next year. But that said, it is great to note that there are many student delegates with us this morning, availing of this unique opportunity to learn from and participate with some of Ireland's leading scholars and practitioners. So I suppose there's always pros and cons of the way we end up organising these events. And in every facet of our lives, whether it's social, economic, or political, discussions are happening about the need to protect our environment. And I think what we're seeing is those discussions are now really taking centre stage. And indeed, this sharp awareness our growth in the awareness of the general public of environmental issues is evidenced through a Red C poll that the EPA commissioned earlier this year. And it reported that 87% of adults in Ireland recognise the environment as an asset and an important asset to the country. So a huge amount of people recognising the importance of the environment. And this is really a potentially powerful source of energy and momentum that we can harness to protect the environment. And of course, I think as everybody participating today knows, the need for urgent action is great. The EPA will shortly be publishing, I think in the coming weeks, our comprehensive 4-year assessment on the state of Ireland's environment. Now, I don't want to preempt too much of what the assessment will highlight, but what I can say is that Ireland has enduring challenges in relation to water and air quality, biodiversity loss, resource efficiency, resilience to climate disruption, developed environmental and transport infrastructure, urbanisation pressures, greenhouse gas emissions, as well as the harms that flow from our unsustainable production and consumption practices. In our coastal areas, we observe that urban wastewater treatment infrastructure is either absent or under capacity, leading to discharge of untreated and polluting sewage. And of course, and has been highlighted recently, our current model of agriculture intensification is resulting in pollution of our natural environment. So there are a lot of challenges that we are facing. And in this context, the role of environmental law at a regional, national and international level and its enforcement are of paramount importance. And of course, here too, our performance as a country against the requirements of EU environmental law is at best mixed. As of August 2020, there are 16 infringement cases and 4 European court cases open against Ireland for breaches of European environmental law. These are mainly related to failures in implementing nature, water and environmental impact assessment legislation. And many of these topics and legislative areas are on the agenda this morning. Specifically, the conference will explore, with the expert guidance of leading practitioners and academics, recent experiences, challenges, and case law in relation to Environmental Impact Assessment Directive, the Environmental Liability Directive, and the Habitats Directive, as well as the implications of the recent judgment of the Supreme Court case in Climate Case Ireland for climate and wider environmental protection. And it is really interesting to note that an independent review of the EPA as far back as 2011, at that stage it was recommended to government that consideration should be given to carrying out a wider review of environmental governance in Ireland so that the issue of fragmentation in structures and processes could be examined and addressed. And as part of that review, it further recommended that this would provide an opportunity to consider whether a specialised environmental court should be put in place, taking into account the experience of systems already introduced in England and Wales. And with the commitment in the current programme for government to establish a new planning and environmental law court managed by specialised judges on the same basis as the existing commercial court model, it's really timely and appropriate that we take this early opportunity provided by the conference to explore its potential from a number of perspectives, and of course including the experience in Britain and I suppose what they've seen over the last number of years. In relation to fragmentation in environmental governance, a more recent review of the EPA conducted in 2019 by the OECD observed that the fragmented nature of Ireland's environmental legislation is reflected in the way environmental protection responsibilities are dispersed across numerous public bodies and government departments with limited formal coordination structures. And in that context, the EPA has come to the view that Ireland needs a national policy position for Ireland's environment, or it risks existing environmental protection measures failing or competing with each other. So one overall national policy position. And this policy position should set out the ambition for protecting Ireland's environment in the short, medium and long term. It could also set out how the legacy of a protected environment for future generations to enjoy could be achieved, as well as emphasise the importance of a clean, safe and protected environment for health and well-being. It should be a national policy position that all government departments, agencies, businesses, communities and individuals can sign up to in order to play their part in protecting our environment. And certainly I believe that the absence of such an overarching national policy position is negatively impacting on integration and success across multiple environmental related strategies, plans and programmes. And really what we're seeing is the sum of the parts do not make up a coherent whole. Collaboration and better connectivity across the different systems and policies are needed, as many are interlinked. They don't exist in isolation. You know, it's having a plan or a policy for water and a separate plan for climate and a separate plan for nature doesn't reflect the reality that all of these are interlinked and our environmental issues are systemic and interlinked. And if we had such an overarching policy, we believe that we will be in a stronger position to promote and support better environmental governance, coherent policy development and implementation, and much more effective legislative enforcement. So all of these considerations serve to underscore the value and importance of this conference today in that it brings together practicing legal professionals, leading academics and researchers, policymakers, concerned stakeholders, as well as professional regulators to explore these emerging challenges and ideas. It also has an important role in supporting the development of competency and capacity in environmental law and its enforcement, as we share our experiences and our different perspectives, and ultimately as we learn from each other. And I, for one, am looking forward to sitting back now and learning and listening from all of you for the balance of the morning. So thank you very much, and I'll hand back to Margaret.
Laura, thank you very much. That was not just an address, but it really was an address that was packed full of insights as to what the real concerns for the EPA are at the moment, the challenges, and what the opportunities are that we can seek to take advantage of at the moment. And in particular, I was very struck by what you said about the need for an environmental policy and legislation to be interlinked to deal with the systemic problems and to have an overarching policy and coherent development. And I think that need is something which was, perhaps with hindsight, we can say, seen by our courts and our judiciary possibly about a decade ago, when the Irish courts really started to be seized with environmental problems that did reveal the systemic issues underlying them, and started to deal with them themselves in a coherent and systemic way by making references to Luxembourg and by developing a sustained body of case law across what is an increasing area. And I think that will be apparent when we see just the scope and the depth of cases that we're going to hear the speakers talk about this morning. And that leads very nicely to somebody who is, I could say very well placed, but I think I ought to say best placed to speak about this, and that is the Chief Justice, the Honourable Mr. Justice Frank Clark. We really are delighted that he is here this morning. He has sat in the High Court and in the Supreme Court in a number of very significant cases concerning environmental law. And I would like to extend all of our thanks to the Chief Justice for making time this morning, and I would like now to hand over to him so that he may address the conference. Thank you very much, Chief Justice.
Thank you very much, Margaret. Firstly, can I say that I'm very happy to have been asked again to participate in this conference. I've considered the programme to be cutting edge in the best sense of that term. I really want to concentrate on two matters. One is an assessment from my perspective, from a court's perspective, as where we stand in terms of dealing with the increasing volume of environmental cases. I think it's dangerous for a sitting judge to comment on substantive law, because that can lead to legitimate complaints of prejudgment and the like. So I leave it up to the expert speakers to talk about the legal consequences of the case law, not least because I note that one of the issues to be considered is the judgment of the Supreme Court in the climate case, which was a judgment which I delivered myself, and I think it's very particularly dangerous for judges to trespass on their own judgment. Though I have to say that I'm nearing the position where I may be able to enter the fray, in that I am in the last year of my term as Chief Justice, so I may be able to express more pointed views if we come to a conference like this next year. But the first point I want to make is to echo a point Margaret Gray made in her introduction. The volume of litigation in the environmental field, I think, continues to grow. It remains a very significant part of the workload of the Supreme Court. That is, I think, in part generated by an issue that I think we do perhaps need to address, which is the rather curious situation that in order to appeal to the Court of Appeal, which is the normal appeal route, as many will know, from the High Court, you need a certificate from the High Court, which must certify that a point of law of exceptional public importance arises. the constitutional threshold for appeal to the Supreme Court simply requires that there be a matter of general public importance. And it's certainly at least arguable that that's a slightly lower threshold. So you have the other curious situation that it could be legitimate for a High Court judge to take the view that the case should not be certified because it doesn't meet the higher threshold, but yet the Supreme Court takes a direct appeal because it meets a somewhat lower threshold. And built into that is the obligation of the Supreme Court under the European treaties to refer any issue which is not act clair in the sense in which that term is used to the Court of Justice. And that can lead to the Supreme Court feeling that it has to take a case because it might feel obliged to make a reference and it can't cut the case off at an early stage. So I think there was some talk around the time when the Court of Appeal was being established that certification process might need to be looked at again. And I think that's perhaps an issue that does need to be considered. The significant number of references, both from the Supreme Court and from the High Court to the Court of Justice, I think also emphasises the now inextricable link between Irish environmental law and European environmental law. Some of it, I think, can fairly be said to be put down to the fact that Ireland has struggled with transposing properly and implementing European law in Ireland. Some of it, I think, in fairness to us, can also be put down to the fact that European law itself is not always clear. Just, for example, within the last year, we could instance the Clone decision, where the court came to a different view, at least on some points, than the Advocate General, making it clear that it wasn't clear what the answer was going to be. So I don't think we should regard this as entirely a domestically created issue. I think European environmental legislation isn't always as clear as it might be. But I do think we will continue to struggle. As Laura mentioned, we have a large number of enforcement cases which are brought before the European courts, but we also have difficulties in implementing European law within the Irish scheme. And I think that's perhaps added to by the point that both Laura and Margaret mentioned earlier, which is the somewhat fragmented nature of Irish policy, which has in turn led to a somewhat fragmented legislative schemes, which can give rise to very grave difficulties of interpretation. If it takes a large number of very experienced counsel to argue difficult points of law, there is always a debate about whether the legislation might have been clearer in the first place and make things easier. I always go back to referencing in that context a case about the aspects of the planning acts which required the ceding of a certain amount of land where significant housing development permissions were given, and recalling a case where 4 of the leading practitioners in the area were all puzzled by attempting to come up with a coherent answer. And I think my judgment said something like, well, the answer I'm giving is not without its problems, but in my view, it has less problems than any of the other possible answers. So I think we do need to address both European legislation perhaps being better, our implementation of it certainly being better, and Irish legislation being perhaps more coherent. That might do the courts out of some work, and practitioners mightn't be too happy with that. But from my point of view, a more straightforward legislative scheme would be something that the courts would welcome. The other significant issue, which is again addressed in the programme that we're going to come to later today, is the question of an environmental court. And as has been mentioned, there is a provision in the programme for government suggesting that something along the lines of the commercial court would be a useful innovation. I just make some observations on that. I recollect some years ago a conference that Áine Ryall organised, which I was due to attend and couldn't attend. I produced a paper which was subsequently published on this topic, and I might revisit just some of those points from a judicial perspective on that. Firstly, I think in principle it's a good idea. As it happens, I served as a judge mainly of the commercial court, perhaps 2/3 of my time as a judge of the commercial court while I was a High Court judge. So I've reasonable experience in how that works, and I think it has worked reasonably well. I think it is important that we keep clear in our minds what we're talking about. If you're talking about the commercial court model, the term commercial court is used. It's perhaps not strictly speaking an accurate term, even though it's one everyone uses, I think, including the judges who sit on it. But it's not an institutionally separate entity. The entity that hears in commercial cases in the High Court is the High Court. It's judges of the High Court who hear those cases. It's an organizational model, if you like, within the overall institutional structure of the High Court, which allows judges with expertise in the area to spend at least, if not their entire time, at least a significant part of their time dealing with those cases. And if I might give my principal reason for thinking that is a better model than an entirely separate institutional court. In other words, a body that is not the High Court or any other court, that is a standalone court with own judges who are only judges of that court. There are a few reasons. Firstly, there are interactions between different areas of the law that can be valuable. There are cross-fertilizations, and having an entirely institutionalized separate specialist court runs the risk of a silo mentality developing. Just give one example. There's been significant developments over the last 10 years, perhaps, in the law relating to the obligation on administrative bodies to give reasons. You could have a very long paper on that topic all by itself. And it has had an impact in the environmental field, with a number of decisions having been made indicating the way in which decisions do need to be reasoned. But it's not a child of environmental law in itself. Indeed, perhaps the seminal case is a case called Malek, a decision of Mr. Justice Fennelly in the immigration field. So you do get these parallel interactive developments in different areas of the law. And I think overly segregating out specialist areas runs the risk of removing what can be a richness in the development of the law as a whole. On the other hand, I think that the time has long since passed when you can expect any judge to be sufficiently expert to deal with complicated cases across the whole range of areas that come before the courts. So I think the way in which you can perhaps square that circle is the commercial court model. And it also prevents judges from perhaps getting too bored doing the same kind of case. You can occasionally be allowed to do other things. And I think that's good for the head as well. So I think a model where within a single institution, such as the High Court, you have a dedicated specialist division, call it whatever you will, which has judges who have expertise in that area, but who also can do from time to time other cases, I think is an ideal way of dealing with it. It also is relevant in the context of resources. Part of the reason I think the commercial court worked was that successive presidents of the High Court were willing to allocate whatever number of judges within reason were needed to handle its workload. If you had an institutionally separate body, and it turned out there was a lot of litigation at the one time, well, how then do you get the judges to deal with it? At least if you suddenly find you need 5 judges because there's a lot of major environmental litigation, well, then they can be allocated, and you can have a pool of perhaps 6 or 10, all of whom are knowledgeable in the area, from whom the number that's needed at any given time can be provided. The last point I'd like to make on the environmental court, the last point I'll make before finishing, is we also need to remember that we perhaps think a lot of the superior court end of environmental law, judicial review of the decisions of the bodies that give permissions, whether planning permissions, environmental licenses, or whatever. And that is obviously a very important part. But a lot of environmental enforcement happens in lower courts, not least the district court. And there can, I think, be, again, issues about our current model of district court, where the country is divided into discrete areas, where, with the exception of Dublin and Cork, there's only one district judge for the area who by and large deals with all issues arising in that area, from public order offences to drunk driving cases to whatever. There may be bigger picture questions about whether that model remains an ideal model for Ireland today, but leaving those aside, it is interesting that another part of the programme for government in a different legal area, the area of family law, is proposing a new structure which will allow for specialised district judges and circuit judges to deal with family law within, again, the same institutional structure. They will still be district judges or circuit judges, but there will be a specific family law structure which will allow judges with expertise and specialised knowledge in those areas to deal with family law cases. And perhaps that's something we also need to think about, that environmental enforcement is not just a matter for a specialist division within the High Court, like the Commercial Court, but how also do we deal with the fact that significant enforcement proceedings may well take place in the District Court or perhaps the Circuit Court before judges who have no great expertise in the area and can't be expected to if they're a standalone judge dealing with all sorts of cases. Reminds me a bit of the debate that's sometimes had about local specialist medicine and the query that's often put up that if the area is too small and it's too localized, save in very routine work, specialists may not retain the expertise to be able to deal with things because they don't happen often enough in their area for them to develop and retain expertise. So I think we perhaps need to widen the debate about an environmental court beyond a division of the High Court to how we handle other areas. I know, for example, in Dublin, there is a specialist district judge who deals with all regulatory matters and therefore has expertise and knowledge in that area, but that can't be replicated in our current model outside Dublin because of the single judge model I've indicated. So I think there's a lot to be debated about how we deal in environmental cases, but perhaps in a wider range of cases, with the fact that we increasingly are giving jurisdiction to the lower courts in respect of important and sometimes complicated matters, and yet are not delivering always the expertise that are needed to deal with those matters. I would certainly support the view that a commercial court type environmental court within the High Court would be a good idea, but I would also suggest we need to think in a more broad-based way about how best to ensure specialist environmental enforcement across the range of our courts. Thank you very much for listening to me. It's been a pleasure to be involved in this conference again, and I look forward in due course to observing the further insights from the leading practitioners and academics who are going to address you. Thank you all very much.